Chair lays out House Bill 4656. Oh, Representative, and recognizes Representative Basut. There's a substitute for House Bill 4656. The chair lays out the substitute to House Bill 4656 and asks, without objection, and asks Representative Basut to explain it.
Thank you, Mr. Chairman, members of the committee, for the opportunity to lay out the committee substitute for House Bill 4656 for you today. Members, the substitute seeks to reinforce a foundational principle of family law in Texas that parents are presumed to act in the best interest of their children. This bill codifies the Texas Supreme Court's unanimous holding in CJC, which affirms that parents have a fundamental right to make decisions regarding the care, custody, and control of their child. It is not up to the courts to determine the best interests of the child simply based on the financial heft of either party in a custodial suit. This bill is a negotiated bill between various impacted parties, and I believe that those parties are signed up to testify for you today. So rather than going through exhaustive details of the bill, I'll defer to their testimony, but I'm happy to answer any questions to the extent you have now, and respectfully reserve the right to close.
All right, any questions of Representative Basut, members? Not hearing any, we'll
Thank you.
reserve the right for you to close and start down the public testimony. Chair calls Steve Wolford. Steve Wolford, going once, twice, three times. Says here that Mr. Wolford was testifying for himself and for the bill. He will be shown as not having testified. The chair calls Cecilia Wood. Ms. Wood is testifying for herself and is testifying for the bill. Is that correct?
That is correct.
Thank you. You may proceed.
Thank you, Your Honor. Chairman Dutton. So it's been a while, long day. My name is Cecilia Wood. I'm a board-certified attorney, and I have been working with people on the language in this bill and with some of the work group for probably close to 10 years, if not longer. And I think that this is an excellent bill. I think that it addresses years of both federal and state case law that and helps judges who might not be family law practitioners, as well as new attorneys who are practicing family law, to be sure that they understand the magnitude of these rights, they understand the presumptions that attach to the parents, then they understand how these need to be played out in litigation. And I know that there are some people that are concerned about some things. What I want to say is that it doesn't address specifically every fact situation. It's applicable to every fact situation. But if there's ever a chance to raise an applied challenge in a case, I would say family law is it. And here's the situation, and here's an example. Nobody would consider a parent who gets angry or decides that, a child is worthless and just ends that child's life. No one would consider that parent who ends a child's life to be a fit parent. But as my mother used to say, every rule has an exception. So suppose that parent is faced with the heartbreaking decision of whether to take the child off life support. Well, that decision can end the child's life, but it does not render the parent as an unfit parent. And that is why we can't go through every scenario. There's so many of us here that have practiced for so many years, and even our own caseloads would have, well, in this case, it could be a problem. But in this case, it's not. It's a good decision for the parent to make. The other thing I like about this bill is that it sets out in the very beginning what you have to do to get over a threshold. Many of our standing statutes do not have that. It's bad. It's bad for the people who are suing if they already have a relationship with the family, especially if it's a family member. If they can't win this suit, which they will not win against a fit parent in almost all circumstances, then now they have no contact with that child or very limited contact with that child, or they're not even part of the family anymore. So we want only lawsuits. We only want children involved in lawsuits where there's a valid concern. And we know what a fit parent is because we have case law that says it's someone that adequately cares for their child. We know what clear and convincing evidence is. telling a jury what that is as opposed to preponderance of an evidence, sometimes that's a little bit more difficult, but we've used that for a long time in termination cases, even in property cases where you talk about separate property and you talk about community property. We know what significant impairment is intended to mean because we have had years of cases that say, this isn't, this is how, in this situation, this would be a significant impairment, but not necessarily in the next situation. And so I urge you to, there's been lots and lots of work. We are all of an agreement that this may be some of the, if there's something unclear, it will sort out. There will be litigation where one person says, well, maybe it was, this happened or maybe that happened, but I believe, honestly believe, and I think many people here today believe that this gives courts lots of ability to know what to do. It gives parents lots of ability to know what to do. It also specifically says that making an agreement where for some period of time you are relinquishing some part of your parental rights is, we recognize that that's often in the best interest of the child, and that should not make you, if you're sick in bed and can't take care of your child for a period of time, chemo treatment or something, and you say, I'm going to let this person take care of my child, but I'm not going to stop being the parent, that's a good decision, and we want to encourage that. So please pass this bill out of committee. Thank you.
All right. Show Ms. Gonzalez on the dais. Representative LaHood has a question.
Thank you, Chairman. In a SAPSER between two parents, is the burden of proof clear and convincing, or is it preponderance?
The burden of proof would still be preponderance.
Okay.
Because if you're talking about two fit parents, now oftentimes in our cases, we're going in and we're saying, my client's a fit parent, but this parent isn't a fit parent, and a lot of times it would be something that maybe they've harmed the child, and for whatever reason CPS isn't involved, and you're like these protective orders we hear about talking about, or supervised visitation, or whatever that you're seeking. So but what we're trying to protect is we're a non-parent, and we always think of the loving grandparents that come in, and want to spend a little bit more time with the children. But, you can live with someone for 6 months, and they have standing to all of a sudden take you to court, and the other parent of the child can't complain about that parent being in the home unless that parent has a protective order or is a registered sex offender, or they know that they're harming the child in some way. They can't, and that's bad. That was the CJC case where mom had this live-in boyfriend and managed to piece enough time together to make it 6 months, and then she died. And he was in trying to get all this, equal parenting time and all of the, standard possession and making decisions, and Dad was like, wait a minute, I'm here. It should be up to me who spends time with my child and who, and that was a question, that was a bad enough situation, but imagine I have a boyfriend and I have a child, and I'm like, this is not working, you need to leave, and now he can sue me. He can sue me for the child. We've got two fit parents, but the standing allows him to come in and do this. So this limits, lawsuits don't help anybody but lawyers. I can say that honestly. Sometimes they're a necessary evil, like an operation or medication that has a side effect. But really, the lawyers are the ones that totally benefit because we go home at night to our own children. So this keeps kids out of the middle of it. They're not going to psychiatrists. They're not going to see guardian ad litems, but the parents, now sometimes I would say the only way this would, in my opinion, the only way this affects two fit parents is if the judge tries to do something that neither parent has suggested would be good for the child. And I've had cases, I had a case like that, where the parents were appealing. I didn't try the case. I was brought in on appeal, but so I filed the motion for new trial. And the judge said, if I have to hear testimony on this, I'm going to send this kid to a military school as far away as possible, which of course she said in Chambers, so I had no way of proving it. And so neither parent could seek temporary orders because that was about the only thing they could agree on. And that child suffered. That child had health problems. We couldn't get it through the appellate courts. It was a horrible situation. But if the judge said, I mean, if two parents want two different things, the judge is still going to have the ability to choose, but not just out of the clear blue, pick something is how I would interpret that. Judge Hayes may have a different opinion on that.
No. I mean, and maybe my question was confusing. I mean, I love the intent of the bill. I'm just confused. I'm just curious. Is the burden of proof between two parents preponderance? But this bill would elevate that to clear and convincing. And I'm a little rusty, but I think clear and convincing is a
Yes.
firm belief that the allegations sought are true.
Yes.
And
yes.
so,
But preponderance it does not say that that applies to two parents. It specifically says between a parent and a non-parent.
okay.
Does the bill affect Troxel at all?
The bill does many things, but it includes the holdings in Troxel. Because if you go back to Troxel, Troxel is the summation of all the federal case law. We have similar things here in Texas. And so it starts with the parents have the right to make decisions for the child. They have the
The
right to the
absolute
care, custody, and control. In that case, the question that where the issue that the non-parent was trying to take away the parent's decision-making power happened to be over possession and access.
Right.
But then in other cases, maybe it's about education. Maybe it's about making medical decisions. Maybe it's about, who knows? Maybe it's about you have a child that is particularly gifted, and somebody in the family, maybe a grandparent says, well, I want this child to not go to school, and I want them to be in this movie, and I want them to, and it's a great opportunity. And the parent's like, I don't think that's the best thing for the child at this point. So it's any decision where the non-parent is coming in and trying to assert some, exercise some control over a fit parent's decision-making ability.
Okay. And I'm sure you heard the earlier testimony in the bill by Representative Bryan. And I want to talk about it, but does this bill impact that bill at all?
Well, if we were going to talk about it, which one was Representative Bryan's bill? Because I don't, are you talking about protective orders, or are you talking about
No.
the gestational agreement?
Yes.
Yes, I did hear that because I thought I had signed up for that. I think it might affect, it might affect this bill to the extent that the non-parent is still a non-parent. And so, for example, and I know that people talk about, it can be very long to adopt a child, and it can be very hard to adopt a child. But once you adopt a child, then that child is your child. In that 2-year presumption period, it's the same for a man and a woman that have a child on their own. In that time, and actually for a man and a woman, it's a 4-year period that they can come in and challenge, and even longer if there was fraud or duress, somebody lied to them thinking they were their child. In this case, somebody knows it's not at least one person knows it's not their biological child. But again, in that less than 2 years, that's already the law that, they're not a parent. So now they're coming in as a non-parent, and they don't have, like a father has to register with the paternity registry, and then he only has a short amount of time to do it, and all of that. So it would affect that, and so perhaps that bill would need to address this. But here's the thing. It starts with, we have these rights as parents. And parents come with these rights, and I say this all the time, so I'll probably say it a million more times and make you all crazy. these are the inherent rights because parents have the responsibilities. And so the flip side is the last lady testified, that somebody can just walk out. They can just walk out until there's some final recognition. Now, you can give rights to that second person, but, I mean, you couldn't, like, if there was the father didn't know, the biological father didn't know that he wasn't going to get to be part of the child's life, and I can't remember, it's been a long time, but where the father, the guy thought it was going to be three of them raising the child. And so he is a parent. So you can't give rights that belong to someone else. In this case, I would say the mother is making this decision so that if she lets somebody adopt the child or there's something built into a law that says this is irrevocable after a certain period of time, then the mother made that choice. She might still have the, she chose to make somebody else a parent as the
Okay.
parent.
Any other questions of Ms. Wood, members? Not hearing any. Thank you again for your testimony.
Thank you.
And I wondered where you were on that gestational bill.
Pardon me?
I wondered where you were on that
I thought you
gestational bill.
did, but then I thought, well, maybe this is my protection so we don't fight. So-
All right, thank you. Chair calls Cody Taylor. Mr. Taylor, you are testifying on behalf of yourself for the bill. Is that correct?
Yes, sir.
You may proceed.
So I'm Cody Taylor. You've seen me now many times. She did a wonderful job. The inherent right of parents is a big, when you walk into a court, it's a big controversy, especially with judges who have been in those positions for many, many years. I'm going to reference a case, Chris Clay. You may have heard of it out of the Dallas-Fort Worth area. That case went all the way to Supreme Court. This is a father of his daughter. His ex-wife deceased. And what happened is that the ex-wife's ex-boyfriend sued for custody of their daughter. So it's hard to keep up with, right? But Chris Clay had to go all the way to Supreme Court. So the lower court did not recognize what she is putting into y'all's plate right now. He had to go through the district court. Court of Appeals even agreed with the lower court, went to the Supreme Court, and the Supreme Court said, no, this is a biological father. The mother has deceased. This is a boyfriend. He has no rights, none, to the child. The problem with this is that it was almost 2.5 years long, and it was hundreds of thousands of dollars, and he actually lost time with his child for a moment there because of what the district court chose to do at the lower level. This is a problem that we're seeing, and Representative Asut, we appreciate you bringing this bill. This is huge. You just asked a huge question about SAPSERs, right? When you walk in and you start, and it's preponderance. It should start at equal, and the only reason why anybody should not have equal time is a clear and convincing reason as to why, not preponderance. Not because I just tell stories very well, I speak well, I'm articulable. It should be clear and convincing as to why either mom or dad should receive less time than the other parent, especially if there is no abuse allegations, there is no investigation involved in that, and there is no arrest or other matters, or drugs, alcohol, or other reasons. If both parents walk into that courtroom on a SAPSER because one person decides to get either separated, divorced at that time, then there should be a clear and convincing. And it should walk in with, if they are fit parents and perceived to be fit parents, meaning nothing's on the table, then it should be clear and convincing as to reasons as to why it would be less than. Equal protections for both parents, mainly for the child. So I can't stress this enough that Troxel even stated this, is that the parents hold the right. They're fit parents, they hold that right, it's inherent. So I very much support what Representative Asut brought up, and I hope y'all pass this out of committee.
All
Thank
right, any questions of Mr. Taylor, members? Not hearing any. Thank you, Mr. Taylor, for being here. Chair calls Andrew Brown, who is for the bill, who is the Vice President of Policy and testifying for the Texas Public Policy Foundation. Thank you. You may proceed.
Yes, sir. Thank you, Chairman Dutton, Vice Chair Hayes, members of the committee. Andrew Brown, Vice President of Policy with the Texas Public Policy Foundation, testifying for House Bill 4656. Section 153.002 of the Texas Family Code states, "The best interest of the child shall always be the primary consideration of the court in determining issues of conservatorship and possession of and access to the child." The reason why we're here today, though, is Texas law currently doesn't have a definition or guidance for how to apply that best interest standard, that ultimate standard that we apply in these cases. And this guidance historically has been left mostly to case law, which constitute a patchwork of varying interpretations that vary based on the facts of each case that comes before a court. This has contributed some inconsistency and unpredictability in the application of the standard. House Bill 4656 provides the statutory clarity and guidance that has thus far been lacking. And as was mentioned by Representative Vasut and others, this bill is the product of multiple sessions of work between family advocates, family law attorneys, judges, members of the legislature. Chairman Dutton, I think you even held an interim hearing about this very issue leading up to this session. The Texas Public Policy Foundation was honored to be part of those negotiations and conversations. And I think the bill that you have before you today is one that has been long anticipated by those of us who have had a vested interest in providing the clarity that House Bill 4656 provides. Fundamentally, it safeguards that relationship between a parent and their child against unnecessary and unjustified outside interference. It also provides that guidance that's necessary for attorneys, judges, and most importantly, families, to help ensure that the law is more consistently applied and is predictably applied across a variety of circumstances. Thank you for your consideration of this bill, and we hope that you will support it in committee. I'm happy to answer any questions that you may have.
Thank you. Any questions for Mr. Brown, members? Not hearing any. Thank you, Mr. Brown, for being here, and thank you for your testimony. Chair calls Carl Hayes. Judge Hayes is testifying for himself, and he's testifying for the bill. Is that right, Judge?
That is correct.
Thank you.
All right, Chairman Dutton, co-chair, members of the committee, my name is Carl Hayes. I am testifying here on behalf of HB 4656, and I am the family court judge in Hays County. I am not testifying as a representative of Hays County, and the testimony that I provide is my own personal opinion. I was one of the judges that was mentioned as working as part of the working group on this. And I would like to say that this, I think, represents the best efforts of all of the individuals that were involved in the process of working towards a bill that sets out a number of extraordinary things. And there's 4 things I want to mention. The first is that this bill establishes the correct burden of proof for cases involving parents and non-parents. As Representative LaHood was asking, in an ordinary case, in any ordinary custody case, it's the burden is preponderance of the evidence. But because of the heightened constitutional issues involved when a non-parent comes in and wants to try to take custody away from a parent, the majority of other jurisdictions use a heightened standard. They use clear and convincing evidence. Justice Lehrman, in her concurring opinion in In Re CJC, said, well, we didn't clarify this. We haven't said it's one of the unanswered questions. Troxel left it as one of the unanswered questions. But the majority of jurisdictions have all settled upon a higher standard, that when someone who is not a parent is trying to take the rights away from a parent, they have to go to clear and convincing. That's what we require the state to do. When CPS comes in and they try to terminate someone's parental rights, it's a clear and convincing standard. So now we've adopted, through this legislation, if the bill gets passed, the state of Texas has adopted the position that when a non-parent comes in, they've got to meet a higher burden of proof, and so that question gets answered. The second thing, that I think this is one of the most important things in the bill, is there is now an affidavit requirement anytime a non-parent wants to come in and assert rights against a parent. Back in 2015, there was put in place an affidavit requirement when a non-parent wants to get possession and access, right? And that's 153-432, 153-433 of the Family Code requires an affidavit to be filed along with the suit. What that did was create a situation where a non-parent, it's easier for them to go in and ask for custody than it is to get possession and access. So we have a lot of people that just go by the blow past the part about trying to get possession and access and just file straight for custody because they don't have to meet the requirement of filing an affidavit. The committee substitute requires now that in any instance where someone is trying to say that a parent is unfit and they're trying to overcome the parental presumption, they have to file an affidavit. And the court, based upon that affidavit, makes a determination about whether or not the case should proceed. This may very well have eliminated the problem that you had in In Re CJC, because in In Re CJC, as you've heard, the poor father in that case had to spend thousands of dollars, take it all the way up to the Supreme Court, spent over 2 years in litigation, when if you had had the affidavit requirement, then the case could have been dismissed the very first time a petition was filed, because the court would have reviewed the affidavit, found that it was insufficient, it didn't show, because in Re CJC, the court clearly says, no one's saying this dad is an unfit parent. There was no evidence that the dad was unfit. And if that was the case and you had the affidavit in place, then you would have eliminated all of that problem. And so this is, I think, a very significant matter. And then the last thing I want to say is, and Ms. Wood mentioned this, one of the concerns was that in CPS cases, to a large degree, the solution that is often reached in a CPS case is to get the parent to agree to let a relative share custody. Okay, that's how they reach agreements. Is they say, look, let grandma be joint managing conservator with you. Let your sister be a joint managing conservator with you. So people reach agreements, and we want them to do that because that's the right thing to do as a parent. The problem is then when they do everything they're supposed to do and they want to get their rights back as a parent, they want to say, fine, I want to take back over this. They lose the parental presumption in some jurisdictions, because some courts have held that if you give up the parental presumption, you give up your parental rights, and you can't then assert your parental presumption later. If you've given up the right to fight the non-parent by agreeing to an order, you then lose that right in a modification. And there were a number of different opinions out of different jurisdictions that treated it differently, how a modification would affect the ability to assert the parental presumption. And so the committee substitute now has in it a provision that says, in a modification action, if you agreed that someone could be a conservator along with you, you don't give up your right to assert the parental presumption. So that facilitates people making agreed orders, and then on modification, they would still be able to pursue asserting the parental presumption. And so I urge the committee to pass this out, and I would yield for any questions.
All right. Any questions for Judge Hayes, members? Not hearing any. I just had one, Judge.
Yes, sir.
Always want to know, is Hayes County named for you?
It is not.
Okay.
It is not. It is one of the serendipitous things that I get to say. I'm Judge Hayes from Hayes County.
Yeah, right. Okay. All right. Thank you, Judge. Chair calls Lynn Kamen. And good to see you. From the
Very
Texas-
good to see you,
From
Chairman
the Texas,
Dutton.
testifying for herself and the Texas Family Law
Yes, Your
Foundation
Honor, I'm on-
for House Bill 4656.
Thank you.
You may proceed.
Thank you, and thank you, committee members. This is a really important bill, and you've heard so much testimony on it. I'm going to try to be really short and sweet. But as Judge Hayes said, one of the most important parts of it is the affidavit that is required prior to going forward with the hearing. It requires a non-parent to present facts that are convincing to support the allegation that denying the relief sought would significantly impair the child's physical health or emotional development. This in and of itself, giving that latitude to judges, could stop people from spending thousands of dollars on these types of lawsuits because it can be denied from the very beginning. Sometimes the parents just don't have the same money that the grandparents have, or that an aunt has, or that an uncle has. This affidavit requirement hopefully will cut down on the cost of litigation and the litigation itself. Also, again, the modification part of the statute is important, or part of the bill, excuse me, is important, because it's important that when parents acknowledge they're having a problem, they may need to go to their parents and say, I have a drug problem. I want to get help. Will you watch my child for a while? They get themselves cleaned up. They go back and say, I'm clean, I'm working, I'm productive, I want my baby back. This requires that the parental presumption has to be overcome because it was done by agreement. And I really want to thank all of the stakeholders who worked on this, including the Family Law Foundation, and we've had numerous hours of conversations about this bill, compromise. We've worked all very hard on it, so we hope it passes. Thank you very much.
All right. Ms. Kamen, thank you for being here. Thank you for your testimony. Let's see if there are any questions.
Oh, I'm sorry.
I don't think so, but thank you again. Chair calls George Saldana. Mr. Saldana, it says here you're testifying for yourself, and you're
Yes, sir.
testifying for House Bill 4656.
Yes, sir. First off, I'd like to thank Representative Asut for bringing this. 50/50 bills, the Senate joint resolution bills that I was talking about, parental rights. Everyone wants their parental rights when it comes to education, to medical. You know, you heard stories from the public, your community, your constituents about parental rights. Father's rights, everyone's been talking about them for years. Everyone knows we have a problem in our family courts. That's why there's bills to push along, you know, judicial reform. But one of the things I started to do was dig into what's the best interest of the child. What is it? Is it a standard? Is it a doctrine? It's a precedent. But one thing I came across was compelling state's interest. Before we can limit a parental right, there's got to be a compelling state interest. We talked about the preponderance of evidence standard. That's a standard. Does a doctrine weigh more than a standard? Because the best interest of the child isn't defined, but the compelling state interest is. It's got to be least restrictive. It's got to be, and then it uses the clear and convincing standard. So everything when we're talking about clear and convincing, the clear and convincing standard comes from the compelling state's interest. So what compels the state to take an interest? Of course, there's child abuse. We have problems in our courts where judges aren't listening to false allegations. Is that in the best interest of the child? Not to take a compelling state's interest to fix that. So yes, you have your issues on the family side, me and my ex, right, going back and forth. But you have other forms of interference that are not in the best interest of the child. And we have to recognize that, and we have been. But when it comes down to it, everyone's yelling about compelling state's interest when it comes to your parental rights. So I believe that when judges are using the preponderance of the evidence standard to limit your fundamental rights, first, third, and fifth at 6 o'clock, I believe that needs to be challenged constitutionally. Taken to a higher court when a dad like myself is asking the legislature to give me more time with my child. And you have mothers in here that are saying they need help, and we're stepping up. I'm part of the Mad Dads group around here in Austin, apparently, because I just want to be a dad to my child. Thanks.
All right, thank you, Mr. Saldana. Chair calls Bryant Wilson.
I'd like to waive, sir. I'm still for the bill.
Can you just, sounds like you're testifying not to testify.
My apologies. Yes, my name is Bryant Wilson.
And it says here you're Bryant Wilson, you're testifying for yourself for the bill, correct?
Yes,
Okay.
I would like to say everyone here has already made a very convincing argument for this. I do not have anything more to add, and I don't want to waste anyone's time.
That's the best testimony we heard all day.
I got it. And I'll leave it at that.
Thank you. Mr. Wilson, let's see, Jeremy Newman, the chair calls Jeremy Newman with the Family Freedom Project, and he's testifying for the bill, correct?
Correct.
You may proceed.
Chairman, members, thanks for having me. My name is Jeremy Newman. I'm Vice President of Family Freedom Project. And, for those of you who've been around for a while, you've probably seen bills on this topic come up quite a few times. Chairman Dutton, you've probably seen it more than anybody else. And maybe the most significant thing about this particular bill is that everybody is for it. And if you've been around for a while, you know that has not been the case in past legislative sessions. And the reason it's the case this time is because all of the stakeholders worked really, really, really hard to figure out how to craft language that everybody could support so that we could put the issue to bed and get some clarity on this issue. And the state of the law on this is nobody disputes that the parental presumption exists. The confusion comes around how do you apply it in certain specific types of situations, and that's what this bill is giving clarity on. And just for some context for you guys, we did a review of the 20 years of appellate cases in Texas post-Troxel in 2000 to try and figure out how often are the appellate courts overturning lower courts for getting this wrong, the parental presumption wrong. And what we found was that in almost 50% of the appeals, they were overturning the lower courts for misunderstanding how the presumption applies. And in a mandamus, which is basically an appeal of a temporary order, it was almost 80% of the time. And the thing that this bill resolves, hopefully, is a tremendous amount of confusion that those numbers illustrate. And I think the additional thing that it does is by reducing the confusion and by reducing the litigation, certainly the unnecessary litigation on the question, it helps reduce the weight, the burden on the family and the children. This is one of the points that Troxel made, is that the existence of the litigation itself is a burden on the family and a burden on the child. And the affidavit requirement in particular that has been mentioned before helps sort of the wheat from the chaff at the very beginning to say, if you're not at least alleging facts sufficient to overcome the presumption, then you can't even get in the door at the beginning. So we're strongly in favor of the bill. We've worked on this in some form or fashion for about 10 years, as have several other people here, and we strongly urge your favorable consideration.
All right, thank you, Mr. Newman. Any questions for Mr. Newman, members?
Thank you.
Not hearing any, thank you. Is there anyone else here who would like to testify for, on, or against House Bill 4656? Chair hears none, recognizes Representative Basut to close.
Thank you, Mr. Chairman, members of the committee. I appreciate the hard work of all the stakeholders involved. They're unanimous. They like it. I hope you like it too. I
Well,
close.
thank you for getting everybody together on it. We have, as one of the witnesses said, I've heard this for a long time, and it's usually never had everybody on the same page.
Well, we're happy to see it and hope we have a smooth passage.
Well, thank you, Cody, thank you.
Thank you, Mr. Chairman.
Goodness. It's the chair's intent to withdraw the committee substitute for House Bill 4656 and leave House Bill 4656 pending.